As Dawn mentioned, I'm a certified elder law attorney, and that means that I have focused my law practice exclusively in the areas of estate planning and elder law. And I've gone on to become designated as a certified elder law attorney. And the way to do that is by focusing hundreds of hours in this area, taking a national full-day bar exam, dozens and dozens of hours of continuing legal education, securing the support of other elder law experts. And so it's a very proud accomplishment in my practice. And in terms of focusing my law practice in this area, in the 1990s, I had a grandmother and a grandfather who were dealing with very significant health issues: Alzheimer's, Parkinson's, TIA, mini strokes, and those issues left them physically and mentally impaired. And I saw firsthand and experienced firsthand some of the great challenges that some of us face in aging and how that impacts us, and how tremendously difficult the laws are, the healthcare system. And at that time I pledged that I wanted to serve seniors and families in trying to face these issues so that we could age with dignity and peace of mind. I'm here today, as you know from the topic, to talk to you about how you might begin to protect your own home and your savings. And as you probably know, many folks, for better or worse, don't get around to protecting what they've saved. I can tell you, just a few weeks ago, I had a client come in and she said, you know, my mom was born in the Depression era. And she and my mom and dad, she was telling me, they worked hard all their lives. They saved. They were frugal. They did all the right things. And Dad passed away, and a year ago, Mom went to a nursing home. And in the matter of 12 months, Mom spent down on that nursing home every penny they had ever saved. And the daughter was telling me this. She was too heartbroken to even tell Mom that that had happened because she knew it would break Mom's heart. And I think all of us here probably know loved ones or friends or family or neighbors who have been in that same situation, who may have lost their savings or lost their home because they didn't plan. And it raises a question: what is the difference between those folks who risk everything, they lose everything, and those folks who are able to age with peace of mind, knowing that they've taken steps to have some asset protection? And in my practice, and I've had many years of doing this, I've observed a lot of different people and a lot of personalities. And I say that it really boils down to three words. Three words. The first is expertise. Those who want protection hire an expert. They get an expert, qualified elder law attorney who knows this stuff inside and out, that this is what they practice every day, and they have expertise on their side. The second word is action. Asset protection requires that you take action. Hemming, hawing, procrastinating is only going to guarantee that you have no protection in the future. And lastly, investment. Asset protection requires investment. A simple will or some plan that you or a family member pulls off the internet isn't going to protect you against anything. And by investing in your planning today, it's going to pay off many, many times over in the future, but it requires investment. And that's really the difference between those who don't plan and have no protection and those who do. Expertise, action, and investment. So I want you to think about that today as I talk. Now let's dig into this. Should I start with the good news or the bad news? The bad news. Okay, we'll get over the bad news first. So the bad news, obviously, there's a lot of threats to your home and your savings as we age. There's a lot of threats out there. And we'll talk about those in a moment in more depth. The good news is there's a lot of planning that you can do to try to minimize those threats and protect against those threats. And whenever I go to a seminar, and I do this quite frequently, even as an expert in this area, I'm constantly going to continuing education, trying to build my expertise, learn new things. I always want to walk away from the seminar with pieces of information that I can implement in my life, in my law practice, in my family, that add value. And I call those golden nuggets. My goal today is that you walk away from this seminar with some golden nuggets that you can put into place to add value to your life and your family. Now, as I'm talking today, I want to be sure everybody can hear me. If something happens and I'm talking too fast, you miss something, feel free to raise your hand. I will do my best to answer questions that you might have. I'd ask, if possible, you try to hold your questions till the end. We'll have a question and answer session, but I know sometimes there's something just so urgent that if that happens, we'll try to address it. Now, what are the 3 biggest threats to your home and your savings when you're aging? Can anybody give me any ideas about the 3 biggest threats? Yes? Government, IRS. So, yeah, taxes. And for some folks, that can be estate taxes. Estate taxes. When you die, someone with $1 million or more is going to face an estate tax in Massachusetts, and we'll touch on that today. That may not apply to everybody, but for some folks, especially with the value of real estate, even in a depressed market, they might be surprised if they're in that threshold, and you've got to plan for it. So we've got one is estate taxes. And I've got a prize for you for guessing. I've got a carry bag that you get to get here. All right? I'll pass that back. Thank you. How about another one? Does anybody have any other guesses? Yes. Health. Costs. Long-term care costs. Health costs and long-term care costs. Absolutely. Here's a carry bag for your shopping. Yeah, long-term care costs can be tremendously expensive. How about a third one? Anybody think of anything else? There's definitely the ongoing cost just of staying in your home and prices of everything going up around us. I've got one more. There you are for your groceries. I have one more. Liability. Liability. Big fancy word. It basically means if you get sued. God forbid if you got sued. Liability is a real issue. So let's break these down. In terms of liability, someone gets hurt. You're out driving. You're in a car accident, God forbid, and somebody gets hurt and they sue you. Now, you have auto insurance coverage, but what if the auto insurance isn't enough to cover the full claim that they've made? Then they look to your home and your savings. Or if you have somebody working at your house, they're up on the gutters, working at the house, they fall off the ladder, they get hurt, they sue you. You've got your homeowner's coverage, but if they sue you for more than that, you've got potential exposure there as well. The next one, let's break this down, the long-term care costs that we were talking about, these health issues. You know, and I'm particularly focused not just on the regular health insurance, which is expensive in and of itself, but that's a topic that's far greater than what we could cover just today in this seminar. I'm particularly focused on what about nursing home costs? You know, by some measure, nearly half of seniors age 65 and over will spend some time in a nursing home. For some folks, those blessed folks, they'll be able to rehab and go home in a very short period of time. And others may require a much longer stay. You know, over the weekend as I was preparing for today, I did some research on the internet, and I found the U.S. government Centers for Disease Control website. And they did some surveying across the country for folks who have been residents of nursing homes. They found that the average duration of a nursing home stay was 838 days, nearly 2.5 years. And we have the fortune, or perhaps misfortune on some levels, of living in a state where the health delivery costs, the health costs, are higher than almost any other state in the country. And when you think about it, that's a big number. If we look at, I got an invoice on a client recently in a nursing home in the area, $428 a day. $428 a day. That's over $13,000 a month. And that is for a shared room with a roommate. You'd think that would get you a private room over the Boston Common, but it's a shared room. And if we look at the average duration of 838 days and we multiply it by $428 a day, it comes out to $360,000. Can you imagine what that would do to your home equity or your savings? So we know there's some tremendous costs that are a concern. And these numbers, of course, are in today's dollars, and we also know that healthcare costs increase, often at a rate above the cost, the rise in inflation each year. Now, I can see that some of you might be thinking, well, can't someone else pick up these costs for me? What about my private health insurance? It just pays for some short-term rehab. It does not pay for long-term care costs. Now, some folks might have long-term care insurance policies, but even those, a good policy might pay $150, $200, $250 per day. But when you're talking numbers of $428 a day, even the long-term care policies don't necessarily go the full distance. And then there's Medicare. Age 65, everybody gets Medicare. Medicare can pay up to 100 days of rehab in a facility for rehab. I have some clients who only get 20 days. It's based on how you're performing in that rehab. So we really can't rely on Medicare to pay long-term care costs. And that assumes Medicare is going to exist in the future as it exists today. And for anybody who watches the news or listens to the radio or reads the paper, we know that Medicare is just one of those programs that's on the chopping blocks in terms of what they're going to do, how they're going to cut it down. And the last program is Medicaid. And in Massachusetts, we call it Mass Health. And Medicaid or Mass Health can pay long-term care costs, including in a nursing home, but it's very difficult to qualify. You don't just qualify automatically at age 65. You qualify by being impoverished. You have to have $2,000 or less of countable assets. And if you're married, your spouse is allowed to keep just under $110,000. Those are some pretty tough standards. There's the rules with regard to how they count and what they count are complex. As a general matter, they count most everything. Medicaid's very broad when it comes to counting assets because they would much rather you pay those costs and pay all your money down than Medicaid to pay them. But the specific rules there are certain limited exceptions to those rules, so it depends. Usually it's going to involve your cash, your stocks, your real estate, anything of value that you have. Often it's going to include your life insurance if it has value. So it's very broad in what it includes. Let me address that in a couple of ways. When I talked about those financial limits for getting Medicaid, there is a 5-year look-back period. So that means when you apply for Medicaid to help pay nursing costs, for instance, they go back 5 years. And they look at all of your financial transactions and bank statements. And what they're looking for is, have you made any transfers of what you own, whether it's bank accounts or real estate, to somebody else? And if you have, they're going to issue a penalty where they won't cover you for a certain period of time because you've made those transfers. In the specific case you're referencing, yes, the 5-year look back is very valid today, but in your particular circumstance, you'd want to make sure, if you've got questions about it, you'd want to really review it with a qualified elder law attorney to confirm that that planning's okay and in place. Absolutely, I'd be happy to. Yeah, I mean, as a general matter, if you're a resident in the Commonwealth, you've got some eligibility potential for Medicaid, but it's the financial qualifications that are the hardest part for most people. Now let's dig into some of these strategies that we can employ and that you can employ to try to preserve and protect what you have. And we're going to start from the simpler strategies and then work our way up to more complex strategies. Simpler strategies you might be able to implement on your own. You might not need an attorney, but as things get more complex, you would. And the first one is auto insurance coverage. When someone comes to me for an initial consultation, before they get in the door, I have them fill out a long worksheet, almost 20-page worksheet, and I ask them questions. You wouldn't believe the questions I ask, but there's a reason I ask the questions, because it gets my gears spinning even before they come in. And one of the things I ask about is their auto liability insurance coverage. You wouldn't believe how low the limits are that many folks come to my office. They have assets they want to protect, and they carry an auto liability policy that gives them $50,000 of coverage if they hurt someone in an accident. When was the last time you heard of someone suing for $50,000 or less in a car accident? It doesn't happen. So the first thing I tell clients, if they have anything they want to protect, is to call their auto insurance agent and make sure that their auto liability coverage is raised up to the maximum, which typically for most policies is $250,000 / $500,000. That's $250 per person or $500,000 per accident. Now that might be a big jump in coverage, but in terms of your premium, it's not going to have a big jump. And the reason is your premium is based mostly on your zip code, your age, your gender, your driving history, but your coverage actually is not going to change your premium a whole lot. It doesn't make sense to be driving and maintaining incredibly low auto limits. It's just too risky. So we got a question in the back about an umbrella policy. This umbrella policy is just like an umbrella. You lift it up, and it's for those rainy days. The way it works is you call your agent, you say, look, I want an umbrella liability policy. That gives you $1 million or more of extra coverage above and beyond your auto and your homeowner's coverage. And that can be the rainy day money in case that someone does get a judgment against you. And the cost of an umbrella policy is not too substantial. I don't want to minimize it in the sense that it's nothing, but usually it's around $175 or $200 a year. If you've got assets particularly that you're concerned about protecting, then I recommend it. And it's fairly modest cost to get great additional coverage. The next topic, I'll come back to you. Yeah, one more question.
The umbrella policy.
Sure.
You need a separate one for your auto and separate for your home.
No, usually the same policy is going to give you umbrella coverage above both of those existing coverages. Now, Homestead Declaration, new law, March 16th, 2011. We updated our homestead laws, and we did a very big update. It's been a long time coming, but now there's a fair amount of confusion out there. A Homestead Declaration is a document that is recorded at the Registry of Deeds, and it's on your primary residence only. Can anybody tell me how much protection value you get from a Homestead Declaration? Does anybody know what the number is? Okay, does anybody know what the current number is?
250?
No? Who said 500? All right. I'm going to pass a shopping bag back to you there. I'll address that question. So we've got a question. It gets recorded at the Registry of Deeds. Whether you have the paperwork or not doesn't necessarily matter. It matters that it's at the Registry of Deeds. Now, the current number, even under the new law, generally is that people have up to $500,000 of protection of their equity in their home. In the case of folks who are over 62 or disabled, you can boost that protection up to $1 million. Now, the new law says if you have a Homestead Declaration that was already recorded, and it was valid when it was recorded, and it remained valid throughout, then it should be valid under the new law. If you have questions whether your Homestead Declaration is valid or is going to protect you, you need to consult an attorney. Now, the biggest change in the new law is that for the first time, they've made it absolutely clear that people who own their homes in trust can enjoy the protections of the Homestead Declaration. So for the first time, a trustee can sign a Homestead Declaration. And this offers great reassurance, especially to a lot of my clients who own their homes in trust. In fact, we're going back and contacting clients from many years ago, having them come into our office to sign the new Homestead Declaration to enjoy it within their trust. And so if you don't have a Homestead Declaration and you own a primary residence, I urge you to work with an attorney to get one signed and recorded. If you do have a Homestead Declaration and you're not sure whether it's still valid, talk with a qualified elder law attorney. And if you own your home in trust, this is especially the time to talk with your attorney to get that homestead protection. Now, Homestead Declaration would be above and beyond your insurance coverage. Let me just give you an example, a story. I have a client, this is a true story. She was aging and dealing with all those issues one might deal with aging. And during a period of time, she was staying at her daughter's house, so she wasn't checking her mail. She had been a customer of her car insurance company for a long time and had paid every month the premium for 20 years. But she was at her daughter's house and the bills were slipping and she didn't pay it for a few months. And you know what happens when you don't pay your insurance. And they sent her a notice. She didn't get it. She wasn't there. They canceled her insurance. She was out driving and got in a car accident. And someone was injured. And they sued her. And they went to court. And I was there with my client. And that lawyer for the plaintiff wanted to take her house away. And I said to the judge, Your Honor, this is a homestead declaration that is recorded on her residence. End of story, period. It is protected. It is off limits. The plaintiff's attorney, he hooted and hollered, and he was upset. But the judge said, that's the law. That's what the protection's there for. She was protected. Thank God that was recorded because she certainly had no auto coverage in that accident. So it can be very valuable to have that homestead declaration. Now, the next topic, this is also new law, guardianship and conservatorship. On July 1st, 2009, we enacted new laws that created something called a conservatorship. Is there anybody here who can tell me the difference between a guardian and a conservator? Good, I'm going to tell you. It's what I'm here for. The issue here is if you, as you age, God forbid you're either in an accident or have a health crisis and become incapacitated, in Massachusetts, no one has the authority to make decisions for you unless you have specifically granted them that authority in either a healthcare proxy or a durable power of attorney. And so if you don't have those documents, or if those documents are invalid or insufficient, your loved ones will have to go into the probate court to pursue a guardianship and a conservatorship. A guardian makes healthcare decisions. A conservator makes financial decisions. That's the difference in our new law. It used to be that a guardian made all decisions. Now we've split it up. So we've got guardian for healthcare, conservator for assets and finances.
You don't need two different people for that?
No, the question is, do you need two different people? No, the same person can be both named as guardian and conservator. Now, without that planning in place, it's a mess. You want to avoid guardianship and conservatorship at all costs. A couple of years ago, the Boston Globe ran an excellent expose on the problem with our guardianship process and our laws. And it resulted in the courts making the process a lot more difficult to protect people. People were being put under guardianship when they shouldn't have been. But the flip side is when you really do need a guardianship, it makes the process a lot longer, a lot more expensive. I had a client who came in a couple of years ago, and I reviewed with them estate planning, and I urged them to sign a durable power of attorney and a healthcare proxy. They decided to take the risk. They didn't sign an estate plan. And about 6 months ago, they lost capacity. They don't have the ability to sign estate planning documents now. And the family has hired me to work this out in court at huge cost to the client, to the family. And we think about the costs. You've got filing fees at the court. You've got attorney's fees. You've got publishing fees. You've got to publish that citation, those legal citations you see in the newspaper. Constable fees to serve documents on the elder. You've got guardian ad litem fees. All of this adds up exponentially compared to the cost of doing the planning right the first time. And even when you get through the process, the judge might appoint someone that you wouldn't want making decisions for you. And your conservator that they appoint won't have all of the authority that you'd like. They don't have Medicaid planning authority and asset protection authority. the conservator has to go back into court and ask the judge for special permission to try to preserve and protect assets if you're in the nursing home. And I've had to do that for many clients. I go in before the judge trying to get special permission. And at that point, you might have a judge who doesn't think you should be able to preserve your assets, who thinks you should just have to pay them to the nursing home. So you don't want to put at risk hoping the judge is going to do the right thing here. You want to avoid all of those costs, all of those expenses, all of that frustration, both for you and your loved ones. And you can do that by signing a power of attorney and a healthcare proxy while you're well. It's not quite that easy, though, because it's not quite as simple as just signing a form, a power of attorney. Lots of folks have powers of attorney. They come to me and they say, Patrick, I have my power of attorney. And I say, great, let me look at it. Because it's not the name of the document that matters. It's the authority that's listed in the document that matters. I have situations where the wife comes in and says, Patrick, my husband just went into a nursing home and he doesn't have capacity and we need to do planning. Now, as a general rule, when that happens, I don't want the spouse in the nursing home for their name to be on the primary residence. We don't want their name on there because Medicaid's going to put a lien on the house. You've all heard about these Medicaid liens. You don't want that. But I had to tell my client, I said, look, you don't have the legal authority to sign and take that house out of your husband's name. She said, sure I do. I have power of attorney. I said, yes, but you've got to look at the authority in that power of attorney. And when we looked carefully, there was no authority that said she could remove his name from that house, that she could transfer something out of his name. We had to go into court, again, at great expense and stress to ask a judge for special permission to resolve this issue. We were able to achieve it. We can do great things, but it's so much more costly and time-consuming that it's much better to get it done right the first time. Now, the client said to me, but I don't understand. A lawyer put this plan together for me. And I said, yes, but that lawyer is very respected, but he doesn't focus and specialize in the area of asset protection, estate planning, and elder law. And the lawyer didn't mean them any harm. It's just he doesn't deal with Medicaid and nursing home, so he didn't realize that if you didn't include that authority, it could really harm the client someday. He didn't intend to hurt anybody. It's kind of like going to the dentist to get an eye exam. They're both specialists, they're both doctors, but you've gone to the wrong specialist. This is an area that's too important to risk on somebody who doesn't know this area inside and out. So if you have questions, if you have a power of attorney and you're sitting in your seat today saying, I wonder if my power of attorney has the necessary protections for me or me and my spouse, you're going to want to make sure you present that to a qualified elder law attorney to review and confirm that it does. I see a couple of questions. Yes, in the front first. The question is, should the power of attorney include the ability to change beneficiaries on IRAs and life insurance? That's a question that you have to deal with on a case-by-case basis. It's really a family question. It's a question about who you're going to appoint, how much you trust them. You can make that decision and customize the power of attorney with your lawyer to get it done right, that suits you. And you can also try to add language in there that might limit how much they could change it. So the answer is yes, but you want to do that cautiously. Or the answer is possibly you might want to include that authority, but you want to think carefully about what the consequences of that would be. Yes. So the question is, look, do you have to specify these individual powers, or can you really just give a general power of attorney? In Massachusetts, what the courts and the law says is your power of attorney has to specifically delineate the authority you're granting. If you just have a simple one-page form that says, look, I give you all the authority I would have to make decisions, it's not enough in Massachusetts to deal with your real estate, to deal with Medicaid planning. So the answer as a general matter is it has to be detailed. It has to be laid out very carefully in that power of attorney instrument. Let me just return quickly to the topic of long-term care insurance. The premiums are substantial. It's based on age and it's based on your health. And for those who can afford it, it can have some protection under the current law. With the right level of long-term care insurance, you can prevent Medicaid from recording a lien on your home. But what I find in practice is that very few people have this insurance coverage, and by the time many folks get to my office, they might not qualify, or the premium would just be too substantial. So I do recommend folks where they have good health or substantial assets, or where they're a bit younger, maybe in their 60s or 50s or early 70s, they could explore it, but it's not necessarily going to be a winning answer for most clients. Let me talk about trusts. Trusts. This is a big issue. I heard someone say that's their favorite subject. Trusts. Now, I have a number of clients who come to my office and they say, Patrick, I have a trust. I'm protected. Or the kids come in and say, we've got the trust, Mom and Dad are protected. And I say, wonderful. Can you just let me take a look at it? And I read it, and right there on the first page, right there in the middle, it says, this trust may be amended or revoked by the grantor. And what that fancy language means is that if you establish a trust and you can amend it or change it, or you can revoke the trust or cancel it, then if you get sick and go into a nursing home, Medicaid gets to step into your shoes and say, well, just revoke it. Whatever's in that trust, we want. So most people actually have a revocable trust. It means that they can access it, they own it, they can change it, they can revoke it. A revocable trust has no protection against Medicaid or nursing home costs. Now, that's not to say a revocable trust is no good. We use revocable trusts. Oftentimes, we use them in tandem with irrevocable trusts, which we're going to get to in a moment. Just back on that revocable trust, they have great qualities. They can avoid probate when you die. They're a great way to manage assets if you become incapacitated. They can provide estate tax planning. They can provide ongoing trusts for special needs beneficiaries or underage beneficiaries, disabled beneficiaries. So there's some great qualities to revocable trusts, but they don't protect against Medicaid. So if you have a trust and you're not certain that that trust is going to achieve your planning goals, you need to make sure you work with a qualified elder law attorney to make sure that trust is going to meet your goals, that you fully understand it. Because the time to figure that out is now, not in a crisis down the road. So let's talk about those irrevocable trusts, which you're hearing more and more about. An irrevocable trust is a trust in which you're putting some distance between yourself and something that you put in to the trust, whether it's a piece of real estate or some savings. You're putting distance between you. You can't just take it back. You can't amend it or revoke it and getting it back. Now, if you put a house, for instance, into an irrevocable trust, Medicaid says that's going to be on the radar screen for 5 years. That's the 5-year lookback period that many of you have heard about. So if you put it into an irrevocable trust, you will not be eligible for Medicaid to pay nursing costs, for instance, for 5 years. So that's a big consequence that you have to be aware of when you're doing this type of planning. And an irrevocable trust might not be the right answer for everyone, but as an advanced planning technique, it can be very valuable. I have clients who say, Patrick, I don't like the idea of having absolutely no control, losing that control. And I think that's a valid concern. And when you're working with your qualified elder law attorney, you need to be asking, well, is there any measures of protection you might have? You can talk with them about whether you might retain the right to replace the trustee. If the trustee isn't doing things the way you'd want, maybe you can fire them and replace them. Or maybe you could change the beneficiaries entirely. So while you can't revoke the trust, you might retain the authority on your death to change the beneficiaries. So there's some really nuanced planning that can be done in an irrevocable trust to get at some of those concerns. The irrevocable trust, as an advanced planning technique, offers great potential to preserve and protect assets, because once you get past a 5-year look-back period, if the trust is drafted correctly, the assets in the trust are off limits to Medicaid or a nursing home. So it can be a very valuable strategy. Now the next topic is I want to talk about probate. Another big change. New probate law, January 2012. So in about 6 months, we have a new probate law. We're going to change the laws as we've known them since the Mayflower came over and have a new law. And before I dig into the new law, let me just ask, does anybody know what probate is? That's right. So the comments are that it's when someone dies, probate is the process by which you go down to court, you file the will, and the judge allows the will and then monitors all of the work that needs to be done to distribute the assets to the beneficiaries. And probate, as we know it, has been a costly, time-consuming process, because in Massachusetts it's been a minimum of 1 year to complete a probate. Under the new law is designed to make it faster, simpler, and ideally cheaper for simple probates and simple estates. And so for some folks that will work out well in that new law. The challenge is that I often find that estates and probates aren't simple, that there's situations in that probate that make it more complex. As you all know, when people die, nothing's ever simple or easy. And so I'm not sure that the new law is really going to make it easy for everybody. I don't think it will. The other challenge with probate is that certainly a will is not going to protect your assets against Medicaid. A will doesn't come into effect until you die. Well, Medicaid and nursing home costs are while you're alive. So it may not be an answer in terms of asset protection. Many of my clients come to me and they have a simple will. I call them I love you wills. The husband and wife, it basically says if I die, everything goes to my spouse. And the other spouse says if I die, everything goes to my spouse. It's really endearing and wonderful and loving. The problem is it doesn't serve many of my clients very well, because a number of folks are more senior and in age than me, and if one of them dies and everything goes into the surviving spouse's name, it's 100% exposed if they get sick or require nursing costs. And I have clients, if their spouse is already sick or in a nursing home, the last thing we want to happen is that if the healthy spouse dies, we don't want everything to just go through the I love you will to the unhealthy spouse, because it's going to jeopardize their Medicaid eligibility and end up being spent down potentially on nursing costs. So there's much better ways of handling that. And what I talk to my clients about is having a will that says, when I die, if my spouse survives me, then whatever I own shall pass into a special kind of trust to be protected for my surviving spouse and to supplement their care for the rest of their life. Now, whatever passes into that trust is now off limits to Medicaid, off limits to the nursing home, and it's there and available for the spouse for whatever they might need. And that's a tremendous advantage. And the way this will works is if someone dies, there's no 5-year look-back period. No 5-year look-back period. So there's really special planning that can be done inside your wills to help preserve and protect assets for a spouse as well. And that's something you'd want to talk about with an attorney. Now, I want to discuss being very careful about relying upon the advice of non-experts. Everybody, it seems these days, has something to say about the area of asset protection or Medicaid or nursing home. I hear clients tell me that, well, the auto mechanic told them that they should do this, or the mail carrier told them they should do that. And sometimes they're arguing with me. And I say, well, I'm the certified elder law attorney. Who do you want to believe? You really have got to rely on expertise. You really have to. And if someone tells you a story, 10 years ago, my great aunt did this or this. Well, maybe they did, and maybe it worked 10 years ago, but let me tell you, the laws have changed in the last 10 years. So when you hear a story for someone or you get a piece of advice, you got to take it with a grain of salt. You really do. And you need to rely on expertise. Now, if someone tells you got to give away your assets, sometimes I hear people say, no, just give it away, get it to the kids, do it now. I worry about that. When you give it away, you have nothing. It's not yours anymore. It's someone else's. Let's say you give it to the kids. Now, they love you. You trust them, and you know they'll do the right thing. But what if that child gets divorced? And now your daughter-in-law or son-in-law says, ooh, wonderful. I'm going to take your money, your house, whatever it is that you gave away. I'm going to take that. And they say, yeah, I never liked my in-laws anyway. I might as well take them for a ride. And you go to the judge and you say, Your Honor, it's really mine. The judge is going to laugh at you and say, no, it's not. It's in your child's name. So if they got divorced, if they died, that asset goes through their estate. If they got in a car accident and got sued, your money, your house could be exposed. So I don't recommend people just giving things away. I think that's a lousy technique. And I recommend you talk to an attorney about better options than that. Also, if you take a house and you give it away to your kids, they're going to have enormous capital gains taxes to pay someday when they sell that house. Whereas if you do careful planning when you die, your kids are going to get a step up in tax basis. So if you paid $50,000 for your house and now it's worth $500,000 and you pass it correctly to them when you die, or they get a step up in basis all the way up to $500,000. It wipes out any capital gains tax that they would owe. So whereas if you just give it to them, they get your basis. And when they go to sell it, they owe very substantial capital gains taxes. So gifting has to be done very, very carefully. Other folks come to me and say, look, someone told me to just get the kids' names on all of our assets, jointly own everything. And again, I think that's a lousy technique. It exposes your assets. Now it's jointly owned with someone. Again, if they got divorced or sued, it looks like they own what was yours. So that's not really a great way to do asset protection. Another myth that you have to be aware of is believing that it's too late to do anything. I have folks who come to me and say, Patrick, it's too late. The nursing home, they told me it was too late and they just said to give it all to them. Well, of course the nursing home is going to tell you that. Don't ever give up. Talk to an expert before you give up. Know what your options are. If the lawyer doesn't know the options, go to a lawyer who does know the options. You really need to make an informed decision. I have folks come to me and they're already in a nursing home, and I'm able to do tremendous planning to preserve and protect assets, even in a crisis. Now, it's more expensive and time-consuming and stressful to do it in a crisis. I'd much rather you do your planning in advance and do it well in advance. But for those who don't get to it or it's not done correctly, we're happy to fix it even in a crisis. But never give up. The other thing is I have clients who say, Patrick, I haven't made any gifts. You know, Patrick, you mentioned that 5-year look-back period. Not me. And I say, okay, tell me about what's going on. And they say, well, I sold my condo to my daughter. Great. How much did you sell it to her for? Well, $150,000. How much was it worth? Well, the assessed value was $300,000. And I say, well, guess what? In the eyes of Medicaid, you have made a gift of $150,000. Hopefully not $500,000. But $150,000 is going to leave you ineligible for Medicaid for a long time. So even if you sell something, beware. If you don't sell it for the fair market value, there could be an implied gift there as well. And then I've touched on this before, which is be careful if you end up in a situation where a spouse is in a nursing home and you've got them listed as beneficiary of your IRA or your other retirement accounts or your life insurance. All that money may jeopardize their own Medicaid eligibility, and be forced to be spent down on their care. There's much better planning that can be done, whether it's through trusts or a will with that special trust that I've talked about. Now, there's other strategies in terms of while you're alive and while you're at home, which is where we all want to be. And I want to touch on a few things about staying home. First off, elder service agencies. Here in Melrose, we have Mystic Valley Elder Services. They're actually down in Malden, but they cover Melrose as an area. And Mystic Valley Elder Services offers an amazing range of services to seniors in a number of communities. And if you haven't spoken to Mystic Valley or to the elder service agency that covers your town, I advise that you do that. Get on their radar screen. They've got great services, great support there. Another one is Mass Health, Medicaid. A lot of people just associate that only with nursing home care. But Mass Health has tremendous at-home programs as well, where Mass Health can actually pay for caregivers to help provide care in your home to keep you home. You still have to qualify financially for it, but the qualification is a bit more liberal than nursing home qualification. So we're able to help many families with the at-home program. Another program to consider is this Veterans Administration, VA aid and attendance benefits. And for certain folks in certain circumstances, that can be a very valuable planning technique. You can get up to about $1,800 or so a month in benefit from the VA if you qualify. It has to be done very carefully because you don't want to jeopardize your Medicaid eligibility in doing any VA planning. Now, I want to conclude by coming back to this point about working with someone who really deals with this area. If you're serious about protecting your assets, your home, your savings against nursing home costs and Medicaid, you have to work with an attorney who deals in this area, who knows what it's like to submit a Medicaid application, knows what the rules are, what the impact is going to be. You've got to work with an expert. And I've given all of you a handout with 10 questions that you can ask to help you find a qualified elder law attorney. And of course, I and my office can answer all of those questions, yes. And whoever you work with, I want you to be sure that your attorney can answer those questions, yes. So I want to wish all of you good luck in the future, and I'd be happy to take questions from you. And I want to thank you for your time today. Yes, I've got a question up front.
Reverse mortgage.
Reverse mortgage. So the reverse mortgage is a great product for the right people at the right time. And by that I mean, if you have other money to rely on, then generally I wouldn't do a reverse mortgage. Some people are pitched to do them even when they don't need them, and it's an expensive process to go through if you don't need it. If you do need it, and it's going to help keep you in your home or help keep your home safe, and that's your only resource, a reverse mortgage can be a good technique. I've had clients who have used reverse mortgages, and it's been a real lifesaver for them. But I urge you to approach it cautiously, make sure you know what all your options are. It might be, for instance, that you might qualify for Mass Health benefits in your home, and you don't need a reverse mortgage. So you'd want to talk with a qualified elder law attorney to confirm whether that's going to be of benefit to you. And most of the reverse mortgage products out there, they don't take your home away unless you're not in the home for 12 months. So if you're not in the home for 12 months, whether that's going to be if you're in a nursing home or if you die, that's when they come to get paid on the reverse mortgage. But the general principle is that you don't owe them anything until you die or you're not in the home for 12 months. I've got a question just in the back there. The question is there any plan to increase the look-back period beyond 5 years? And my first response is don't give anybody any ideas or they might. My second response is I'm not aware of any reasonable discussion to increase the look-back period. I have to say 5 years is such an exceptionally long period of time. I find it to just be just an insulting amount of time, because you can have a senior who is swimming laps in the senior races and at the top of their field, and they make a gift to somebody of $1,000 to their daughter as a small gift, and 4.5 years later they have a stroke. And suddenly their world's turned upside down, and now they're told that that $1,000 gift they made when they were an Olympic athlete, a senior Olympic athlete, is going to disqualify them for Medicaid. That's a really harsh penalty. And we've had this very harsh rule in effect since 2006. I don't think it's going to get any easier. I don't think they're going to make it 3 years or 1 year anytime soon. But I don't think they could reasonably make it much longer because it becomes laughable. I mean, you know, how do you get much longer? It's so unfair. Yes?
Can you talk about the penalty imposed?
Yeah, the penalty. So let's just use a hypothetical example. You're age 75 and you're married and your granddaughter's getting married and you give a gift of $10,000 to help pay for the wedding. You do it when you're healthy. You have no intent of getting Medicaid care. You have no thought that you might even require nursing home care. 3 years later, your spouse gets sick. My gosh, now they're in the nursing home. And you've got to apply for Medicaid. And a $10,000 gift, if the caseworker issues a denial, which they may, and impose a penalty period, is going to result in you being ineligible for Medicaid for roughly a month and a half or 2 months. So it's a very substantial penalty. And the penalty starts on the date that you're otherwise eligible for Medicaid. So it's kind of tricky to explain, but it basically means that you would already have under $2,000 in assets, and now they're telling you to pay the nursing home a month and a half, and you say, well, wait a second, I only have $2,000. How could I pay the nursing home? And they say, tough beans. So it's a really tough process. That said, you certainly can advocate in working with a qualified elder law attorney in the Medicaid process. You can advocate with Medicaid that the gift was not made in connection with Medicaid planning or asset protection. And so there's advocacy that can be done, but you're at the mercy of the caseworker, and so it has to be done very carefully. In the far, far back. Yes, the question is there an amount that you're allowed to give? Wouldn't it be nice if Medicaid just said, look, you're allowed to give up to $100 for birthday presents and Christmas presents and Hanukkah presents? No, they just keep it vague and ambiguous. So you have no idea whether they're going to disqualify you for that $50 gift or that $500 gift or that $1,000 gift. It's really up to the caseworker as to how difficult and how uncompassionate perhaps Medicaid's going to be. So there is no guideline on that in this Commonwealth. There is no guideline on it. They don't say you're automatically allowed to make birthday gifts or graduation or wedding gifts. And that's why it's such a harsh penalty. Yes? Well, no, it's not correct. If you've got a married couple and you split up your assets and one of you goes in the nursing home, Medicaid looks at everything. It doesn't matter if it's in one spouse's name or the other spouse's. They count it all as countable assets. So splitting it up doesn't just preserve it and protect it against Medicaid. That's too easy a strategy. Medicaid figured that one out and said no. So you've got to do more careful planning than that. Even if, as long as it's in one, if you're a married couple and it's in a spouse's name, and one of you goes into a nursing home, it's not protected, because the way Medicaid works is if you're married, they count whatever's in your name or your spouse's name, regardless of the 5-year look back. Yes, a question here. Well, the question is, what if you gave $5,000 in cash as a gift to someone? No one can track that. Well, the way it works with Medicaid is they look at 5 years of your financial statements. And if they see an entry, $5,000 cash withdrawal, I can assure you they're going to say, where did this go? We want receipts. So that doesn't work. That doesn't necessarily work either in terms of making, if you were trying to make some substantial gift. They can get around that too. Any other?
You're making a strong argument here for a safe deposit box.
Although they ask what's in the safe deposit box too. No, Medicaid's a very difficult process, and that's why you really need, if you're going through that process, absolutely you need a qualified elder law attorney to lead you through it, in my opinion, because it is just a minefield, and you have to do it very carefully. Gifting can be very challenging for seniors because there is no clear guideline on what's permitted. So the question is, if you move out of state, how are the laws in other states? Their laws vary from state to state. In some ways, Massachusetts is actually quite good and quite generous, and in other ways, we're more difficult and less generous. So it does vary from state to state. I don't have a quick fix solution where I tell people, well, just move to this state and you'll be okay. I'm not aware of any state where Medicaid is a simple or easy process. You just have to turn on the evening news to see that every state is financially strapped, and the federal government is. And so they're all struggling. They want to make these programs as difficult as possible to save money. So just a question on trusts and having trustees. You can always have two trustees of the same trust, or you can have two different trusts with one trustee each. Yes, you can have 1, 2, 3 trustees on a trust. It's up to you and your attorney to design it to what suits your needs. I want to, yes, one more question. Filing for Homestead Declaration. Well, very carefully, under this new law, there's a number of different forms floating around, and some of them conflict. And even though the new law came out, there was a considerable disagreement about what needs to be on that form to be a valid Homestead Declaration. And title examiners have debated. And so there's been some shift and change just in the months following March 16th. I advise that someone, if they want to record a homestead, you work with an attorney who knows what the law is and what's required to be in that homestead to be valid. That's what I suggest people do. I want to thank everybody for coming today, and I want to wish you well. Thank you.